Hi everyone, I'm Agent Daphne.
I'm Agent Ejin.
I'm Agent Adrian.
I'm Ong Eng Hong.
And I'm Ejin Nimesha. Miss Puteri, we
We
accept.
accept the mission.
Based on the scenario video, the couple were facing a hard situation where the bank intended to exercise their right to foreclose their residential house if they were unable to pay the mortgage payment before 15th of that month. This presentation evaluates the current law on rights of the mortgagees in relation to foreclosure, possession, sale, as well as the balancing factor to protect the rights of mortgagor. In addition, the content of this presentation will also relate to the effect of the contemporary COVID-19 pandemic on the rights of the mortgagees and the balances in regards to the mortgagors. The basic purpose of having a mortgage is to raise enough capital to purchase land and convey the land as security for the payment of loan. As stated by Dixon, mortgage can be considered as an extremely flexible idea in the law of real property. What is a mortgage? The definition can be found in the English case of Sanley and Well, where mortgage is a loan that conveys the property as a security for payment of debt. Nonetheless, it is interesting to note that the mortgagor can always redeem back his own property after completing the payment, even though the legal date of redemption has passed. This concept is provided in the case of Thornborough and Baker and Jones and Morgan. Before 1926, Morris stated that mortgage in the early days is called a debt pledge, and the transaction was a depressing one from the mortgagor's perspective. This is because the interest of the land is entirely transferred to the mortgagee. Fortunately, after the reform, our current law reserves the interest in the hands of the mortgagor, and they need not transfer the title deed. Legal mortgage can be created in an unregistered land or a registered land. In unregistered land, it can be done by either a long list or a charge by deed that is expressed as legal mortgage. For registered land, it can now only be completed by way of registered charge over the land, and the deed as well as the registration of the legal mortgage are required under Section 52 of the Law of Property Act 1925, hereinafter referred to as the LPA 1925, Section 25 and Section 27 of the Land Registration Act 2002, hereinafter referred to as the LLA 2002. Despite legal mortgage, equitable mortgage can also be created, and there are three ways to create it. Nevertheless, the most crucial step is to register the equitable mortgage in either registered land or an unregistered land in order to protect their rights.
The right to foreclosure is one of the remedies available for the mortgagee, where the mortgagee's equitable right to redeem is extinguished and the rights over the mortgage property will be transferred to the mortgagee, making them the absolute owner of the land, per Section 88 and 89 of LPA 1925. The right of foreclosure arises as soon as the legal date for redemption has passed and the mortgagor fails to repay the amount owed. When such an opportunity arises, an application to the court is required to exercise the right of foreclosure. Usually, the court will grant the mortgagor an extension of time to repay the loan, and this generally lasts for 6 months. If the mortgagor fails to repay the loan again, the foreclosure becomes absolute. However, the court has the discretion to reopen the foreclosure absolute to allow redemption at a later date when it is so satisfied. Despite that, the right to redeem will be defeated if the property is already sold to a bona fide purchaser. This remedy has been unpopular for many years as seen in talk against mortgage services, as it is rather draconian in nature and extinguishes all redemption rights of the mortgagor. Furthermore, the mortgagee is not obligated to account to the mortgagor any surplus value of the property after the foreclosure. While it seems that the scale of protection is heavily tilted towards the mortgagee, it is submitted that the right of foreclosure is burdensome to them as well. Firstly, exercising this remedy is a slow and cumbersome process, as the Chancellor is very careful in protecting the mortgagee's interest that the period of equitable redemption is extended at any slight showing of ability of repayment. In Edward against Cunliffe, the court granted 4 separate extensions to the mortgagor, even though the third one was expressed as his final prospect of redeeming the property. As a result, this unnecessarily extends the process of mortgagee in obtaining his remedy. Additionally, even though it is absolute by name, foreclosures are not definite. As discussed earlier, the court can exercise its discretion to reopen a foreclosure absolute. This was seen in the case of Berg against Langton, where the foreclosure was reopened after 16 years. This provides uncertainty for the mortgagee, as foreclosed land can be redeemed at a later time when the court is so satisfied. For this reason, foreclosed land also remains undesirable by purchasers and unmarketable until a considerable period of time has passed. In fact, Maitland opined that one is not very safe in purchasing foreclosed land, owing to this meddlesome equity. Foreclosure is not a process upon which prudent mortgagees will place much of their reliance on. Despite that, it should be noted that with the current position of the law, this remedy is virtually obsolete, because any attempt to trigger it would almost certainly be replaced by the court ordering sale instead. This is due to the statutory control on the right of foreclosure as stipulated in Section 91(2) LPA 1925. Courts generally would prefer an order of sale in lieu of foreclosure, and this is no different in the case of a pandemic. As foreclosure is a harsh remedy, courts have developed protection for mortgagors to balance the interests of both parties. However, this also makes it an impractical remedy for mortgagees to pursue, hence it is not very relevant anymore.
Another right exercisable by the mortgagee is the right to possession. There are few general rules which are relevant to note. Firstly, a mortgagee may exercise this right the moment the ink is dry on the mortgage, as established in Formates against Dudley Marshall. This means that this right is exercisable from the very moment the mortgage has just been executed. But of course, in practice, mortgagees would normally exercise this right only if the mortgagor has been defaulting on mortgage payments. Secondly, it is not necessary for a mortgagee to obtain a court order before this right can be exercised. This method of possession is also known as peaceable re-entry and was recognized in the case of Rapajalak against Barclays Bank. However, the court did caution that this method of possession may be dangerous and uncivilized. Thirdly, when the mortgagee has successfully taken possession over the mortgage property, he will be strictly responsible for any income generated by the possession. This implies that if the actual income earned from possessing the property is lower than the reasonably expected income, the mortgagee will have to make up for any shortfalls in income earned to the mortgagor.
Mortgagees' right to possession appears to give them a higher footing as compared to the mortgagors in the event of default in repayment. However, as Martin Dixon put, one should always be reminded that for every single successful possession order, a family will be rendered homeless or separated from each other. Fortunately, there are legal mechanisms embedded to mitigate the harshness of this right. One of these is provided under Section 36 of the Administration of Justice Act 1970, as amended by Section 8 of the Administration of Justice Act 1973. These provisions provides that the court may suspend, adjourn, or postpone an application made by the mortgagee for the possession of a dwelling house at its discretion, provided that it is satisfied that the mortgagor would be likely to repay the sums due within a reasonable period of time. Two benefits are to be noted from this statutory provision. Firstly, the phrase dwelling house constitutes a protection towards the right of the mortgagors who are actually occupying the mortgage property. As affirmed in Royal Bank of Scotland against Miller, whether this property is regarded as a dwelling house or not is to be determined on the date whereby the possession order is sought, not when the mortgage was actually executed. Secondly, this provision provides that the court may grant an extension of a reasonable period depending on the financial capability of the mortgagors. As held in Cheltenham and Gloucester's Building Society against Norgan, reasonable period should be determined after taking into consideration the interests of both parties, specifically the mortgager's ability to repay the debt. Halley observed that the courts are usually sympathetic to give the mortgagors a second chance unless their cases are absolutely hopeless. Therefore, Section 36 aims to provide mortgagors a temporary relief for their short-term difficulties, meaning that homeowners will not simply lose their home due to the sudden or unforeseeable financial constraints, just like Mr. and Mrs. Hortons in this scenario and many other families who lost their incomes amidst the COVID-19 crisis. Nevertheless, Section 36 is not flawless. As pointed out by Martin Dixon in his article, mortgagees can simply circumvent this provision by exercising their contractual right to possession without applying for a court order. This is in light of the case of Rebecca against Barclays Bank, which held that Section 36 can only be triggered if the mortgagee takes possession via a court order. Although the mortgagees have to be wary in exercising their contractual right to possession so as to not commit an offence under Section 6 of the Criminal Law Act 1977, clearly they can definitely do this without a court order to prevent the mortgagors from seeking protections under Section 36. Another possible issue is when the mortgagors seek to rely on Section 36 to stop the possession order to sell the properties themselves in order to settle the debt pursuant to Section 91 of the Land Property Act LPA 1925. Sometimes the mortgagors would do this because they will want to terminate their mortgages if they can no longer afford the interest payments. According to Cheltenham and Gloucester against Proust, Section 36 cannot be invoked to stop the possession order for situations of negative equity, whereby the sale value of the property is insufficient to account for the remaining mortgage payment and when the mortgagors can't even account for the shortfalls. The case may have severe implications, specifically in times of COVID-19 crisis, because the properties market is not doing well and situations of negative equity will arise frequently. This is because mortgagees can repossess the mortgage property without being challenged in order to keep the mortgage alive and continue charging interest payment on the mortgagors. Nevertheless, it is important to note that Krauss did not explicitly overrule the cases of Port against mortgage funding and Polonsky against Lloyd Bank mortgages, whereby the courts liberally interpreted Section 91 of the LPA 1925 to allow suspension of possession orders in situations of negative equity, despite Section 91 subsection 2 does not expressly prescribe for the courts to suspend any possession order. Martin Dixon observed that the courts in Port and Polonsky appear to have invoked their inherent jurisdiction to suspend the possession order. However, as the law stands today with the case of Krauss, mortgagors are unlikely to be able to rely on Section 36 of the 1970 Act to suspend a possession order in order to sell the property if the situation of negative equity arises.
Due to the nature of possession being a right rather than a remedy, the courts have developed other non-statutory limitations on the mortgagee's right to possession. Firstly, in Kennel and Mudby, Lord Denning opined that equity only allowed mortgagees to take possession only when they had justifiable grounds to do so. However, although this was intended to provide mortgages with additional protection from the overwhelming rights of mortgagees, it is doubtful as to whether this equitable principle will hold water in future cases, as it clearly contradicts with the mortgagee's absolute right to possession. Secondly, the House of Lords had taken a large and bold step in the case of William and Glyn's bank against Boland by declaring that a mortgagee could not take possession from a mortgagee's spouse if she had an equitable interest in the property and was in actual occupation when the mortgage was created. This is because the mortgagee's spouse would have an overriding interest over the property, which would take priority over that of the mortgagee's interest over the land. Currently, this type of overriding interest has gained statutory recognition under Schedules 1 and 3 of the Land Registration Act 2002. Lastly, in view of the age of human rights, the courts are seen to be passionate defenders of the rights of mortgagors. The European Convention on Human Rights, or the ECHR in short, which was imported into UK domestic law via the Human Rights Act 1998, provides for the right to private and family life and the protection of property under Article 8 and Article 1 of Protocol 1 respectively. In the case of Hounslow London Borough Council against Powell, which approved the decision made in Manchester City Council against Pinnock, the Supreme Court recognized the need to consider Article 8 of the ECHR by ensuring that the issuing of a possession order would be proportionate and not impinge on the mortgage's rights under the ECHR. Though we have yet to witness a case where a mortgagor successfully makes a claim that an order for possession had violated his human rights, cases such as Pinnock and Powell give a glimmer of hope that such claims may succeed in the near future. Sarah Neild, in her article, stated that 3 elements must be considered by the courts in justifying the possession of a mortgage property. Firstly, there must be a legitimate aim in enforcing the mortgage through possession. Secondly, there must be adequacy in the process of obtaining possession. Thirdly, the aim of the possession must be proportionate to the consequences suffered by the victim. All in all, a mortgagee's right to possession is indeed one that is indispensable to him, but it is also one which is so powerful as to bring a mortgagor down to his knees. Fortunately, not all hope is lost for mortgagors, because the current laws can be said to have slightly tilted the balance in favor of mortgagors as compared to the laws in previous decades. Also, it is more likely that the courts will be more considerate towards mortgagors, especially in possession proceedings with the COVID-19 pandemic plaguing the nation, since many people would have been affected by it financially.
The subsequent remedy for mortgagees is the power of sale. This gives rise to rather serious consequences, extinguishing the mortgage's right over their property. As such, careful requirements have been provided for in statutes, reinforced by common law and equity. Here's how it works. Pursuant to Section 101, Subsection 1, Part 1 of the LPA 1925, every mortgagee possesses the right to sell, whether explicitly provided for in the mortgage deed or not. However, this right only arises after the fulfillment of 2 preconditions, namely the power of sale arising and the power of sale becoming exercisable. In order for the power of sale to arise, the mortgage firstly must be made by deed, secondly, the mortgage money must have become due, and thirdly, there must be no contrary intention expressed in the mortgage deed. Section 103 of the LPA 1925 then encapsulates the stage at which the power of sale becomes exercisable, contingent on the fulfillment of one of the 3 conditions. Firstly, where the mortgagor defaults on payment for 3 months after being served with the notice of payment. Secondly, after the interest payable is 2 months in arrears. And thirdly, where a term of the mortgage deed or the LPA has been breached. If the mortgagee executes the sale prior to the fulfillment of one of these conditions, the purchaser may still keep the land and have the mortgage transferred to him unless the mortgagee is able to prove that the purchaser had awareness of the mortgagee's fault by virtue of Section 104 of the LPA 1925. This may all seem disproportionately unfair to the mortgager, which is where common law principles come into play. A mortgagee exercising this power must act in good faith and use his powers for good purposes, as per the case of Kakmir Brick against Mutual Finance. They must take care to obtain the best price reasonably obtainable at that point in time, but need not pursue avenues that will increase the value of the property, such as planning permissions. Moreover, the mortgagee need not wait for the property market to peak, even if selling it at that point is contrary to professional advice, but should do so only if it is a short delay which is known to the mortgagee. This point is relevant, especially so in times of crisis like COVID-19, where the length of this pandemic is uncertain. Mortgagees need not wait for the pandemic to be over in order to exercise their right to sale, which will be combated by governmental measures that are discussed later on in this video. They generally may not sell to a purchaser with whom they have a connection to, including themselves. If they choose to do so, as in the case of Sir Kwong Lam against Wong Chit Sen, where the property was sold to an employee of the mortgagee must have obtained the reasonably best price with the burden of proof on the mortgagee. Failure to act in accordance with all these principles will usually result in the property being undervalued. In such a situation, the mortgager is entitled to claim damages. On the flip side, the sale gives the effect of paying off all associated liabilities and terminating the mortgage if the loan has been repaid in full as per Section 105 of the LPA, with the leftover proceeds, if any, given back to the mortgager, effectively preventing mortgagees from making a profit. Moreover, should the mortgager themselves choose to apply for judicial sale, they can do so under Section 91 of the LPA 1925 in order to pay off their mortgage. Now, practically, the power of sale is necessary and acts as a security for mortgagees, which allows mortgagors to purchase and enjoy the property in the first place. However, in situations and times of crisis such as this one, where the property market is facing a downturn, some policies could be very unfair to the mortgager. Perhaps the UK can follow in Australia's footsteps with the Property Law Mortgagees Power of Sale Amendment Bill, introduced, which created a statutory duty for mortgagees to take reasonable care to ensure that the mortgage land sold is not sold for less than its market value. All in all, the statutory provisions work hand in hand with common law principles to effectively balance the rights of both the mortgager and the mortgagee.
Nevertheless, governments usually alter policies to enhance this balance during times of crisis. This is because the crisis would usually affect the economy of the country and subsequently affect the income of the people and ability to repay their loans. An example would be the current unprecedented COVID-19 pandemic, where the United Kingdom government provided a mortgage repayment holiday to support those mortgage lenders and administrators. As mentioned by Benedict and Ellie, a common support measure for the real economy taken in the United Kingdom and other jurisdictions is the introduction of payment moratorium in relation to mortgage payments, and more extensive measures are placed under the proposed Corporate Insolvency and Governance Bill. The purpose of it is to provide breathing space to mortgagors in financial difficulty. In conclusion, the right of mortgagees to exercise foreclosure is obsolete nowadays, as it does not really benefit both the mortgagee and mortgagor. Nonetheless, the mortgagee's right to possess and right to sell are still relevant in the current law. The law pertaining to these rights provide a relatively good balance between the mortgagee and mortgagor, where rights of both parties are safeguarded. This is Agent Daphne reporting to Central Command. Mission accomplished.